My grandfather built the dam in 1952, 180 feet of compacted earth, faced with limestone he quarried from Buncombe County. Two 36-inch cast iron slide gates on the eastern face, set into the structure by hand. He built it to impound Drum Creek for agricultural use. And for 70 years, that's what it did. His hands on the wheel cranks, then my father's, then mine. I left for a 16-month federal forestry contract in the Pacific Northwest. Before I left, the drainage corridor below the dam was what it had always been. Brushy, irregular, seasonally wet, a working creek floodplain doing exactly what a creek floodplain is supposed to do. I came home to a park, paved parking lot, graded turf grass, 2 dark green benches, a 1.2-mile trail system with orange blazes on my trees, a sign at the trailhead, Ridgeline Estates Nature Preserve, maintained by the Ridgeline Estates HOA, 3 acres of the Drummond family's drainage corridor, cleared, seeded, and signed by a developer who had never spoken to me, never surveyed the boundary, and never once looked upstream. The benches were in my dam's inundation zone. I stood at the wheel cranks and looked at them. Then I called my attorney. The gates stayed where they were. They didn't need to move. The paperwork was enough. But first, drop your location in the comments and don't forget to like the video and subscribe for more interesting stories like this. The gravel road into the Drummond property had a sound, not a metaphor, a literal acoustic signature, the specific crunch of packed limestone screenings under truck tires that Caleb had been hearing since he was old enough to ride in the passenger seat of his father's pickup. The tree canopy closed over it about 40 yards in from the highway turnoff, the hardwoods arching across the road in the way they did on old access roads that had been cut through an existing stand rather than cleared for it. His grandfather had done it that way deliberately. Take as little canopy as you need. Use what's already there. He had been on that road 10,000 times, coming back from school, coming back from college, coming back after his father died, and the property became his responsibility in the way that properties become responsibilities, not through a single moment of decision, but through the accumulation of seasons in which someone else is no longer there to make the decisions. He had been gone 16 months this time. The Pacific Northwest contract, old-growth timber inventory in the Cascades for the U.S. Forest Service, had run 4 months longer than projected because the stands were more complex than the initial survey indicated, and because the kind of work that requires you to walk every acre doesn't compress well when the acreage is larger than expected. He had called Burl Hensley every 2 weeks during the first year, monthly after that, when the contract rhythm absorbed most of his attention. Burl had started texting in October. Burl was not a texter by nature or preference. He had learned to use the phone Caleb had given him out of practical necessity. The property was large enough that walking back to the farmhouse to make a call from a landline was a genuine inefficiency, and he had developed a texting style that reflected his verbal economy. Subject, object, period. They're grading your east field, October 14th. Contractor back, paving something, November 3rd. Putting in benches, November 29th. There's a sign now, you need to see this, December 8th. After that, the messages had become more frequent and slightly longer, which in Burl's register meant something had crossed from a nuisance into a problem he didn't have the vocabulary to categorize by text message. Caleb had called twice. Burl had described what he was seeing and then said, both times, "Just come home and look at it. I can't describe it right." He was looking at it now. He had turned east off Highway 276 and driven the gravel road for 3/4 of a mile before he saw the first thing that was wrong. The boundary fence was gone. The HOA's fence, a 4-board wooden fence that had marked the eastern property line since Ridgeline Estates was developed in 2004, running along the recorded boundary for the full 2,200 feet of the shared edge, had been removed and relocated. He could see the new fence line from the road, set back significantly from where the old one had been, enclosing a wide band of his land within the HOA's eastern edge. He parked the truck on the gravel shoulder and got out. Beyond the relocated fence, a paved parking area. 24 spaces, cleanly striped in fresh white paint, a handicap-accessible bay at the near end with the required blue markings, a decorative split-rail fence along its outer edge, with a landscaped planting strip that someone had put in recently enough that the shrubs were still in nursery shape. The parking area occupied what had been his brush line, the irregular, self-seeded edge of mixed hardwood regeneration and creek bottom vegetation that had been building itself back for 2 decades along his eastern boundary. Gone. Graded flat, paved, striped, landscaped. Beyond the parking area, 3 acres of his land, cleared, graded to a gentle crown, seeded and mowed to the specific manicured standard of a community park, turf grass in a uniform cut, the kind of maintenance you achieve with a commercial zero-turn mower on a weekly schedule. 2 dark green painted park benches sat facing the tree line at the far edge of the graded area. A gravel walking path curved from the parking area's far end toward the timber stand, disappearing into the trees at a gap where a trailhead had been constructed. Cedar post frame, cedar crossbeam, a routed wooden sign mounted at eye level. Ridgeline Estates Nature Preserve. Maintained by the Ridgeline Estates HOA. Please stay on designated trails. A laminated trail map was bolted to the right-hand post. Caleb walked to it and read it. The map showed a 1.2-mile loop. The trail entered his timber stand at the trailhead, curved north along the creek corridor, crossed Drum Creek at a point marked Bridge 1, swung uphill through his upper timber, crossed the creek again at Bridge 2 on the return leg, and looped back to the parking area. The trail was marked with orange blazes. He could see them from where he stood, the paint marks on his trees, spaced every 100 feet or so into the stand. His trees, orange blazes he had not put there. 3 residents of Ridgeline Estates were currently on the trail. He could see them from the trailhead. A woman pushing a stroller on the gravel path, moving away from him into the timber. 2 men in athletic wear, talking, moving at the brisk pace of people doing a purposeful walk. On a Tuesday afternoon, in February, on Caleb Drummond's land. He stood at the trailhead sign for a long moment, read the sign again, looked at the trail map, looked at the parking lot, the benches, the landscaping, the fence. The HOA's relocated fence that now enclosed his brush line, his creek edge, and 3 acres of his drainage corridor inside what the sign was describing as a community nature preserve. He walked the full perimeter of the cleared area without speaking to anyone. Then he walked uphill. The path from the graded field into the timber stand was steep enough that you needed to find your footing in the first 20 yards before the grade leveled into the mid-slope traverse. Caleb had walked this particular piece of slope since childhood. He knew where the root was that caught your toe if you didn't step wide, knew the place where the soil changed from the creek bottom silt to the harder clay of the hillside proper, knew the line of large tulip poplars that his grandfather had marked with surveying stakes in the 1960s as a reference line for the upper timber boundary. He walked through the timber for 8 minutes to reach the upper plateau. The plateau was a natural bench in the hillside topography, a flat shelf of land above the drainage corridor where the ground leveled before rising again toward the ridge. His grandfather had chosen it in 1952 because it was the natural impoundment point. The creek narrowed at the plateau's eastern edge, the hillside rising on both sides to create a natural saddle, and a relatively modest dam across that saddle could back up a significant volume of water. 180 feet of compacted earth, 14 feet at the tallest section, faced on the downstream side, with cut limestone blocks his grandfather had sourced from a quarry in Buncombe County. The downstream face was still in the condition he had maintained it in for the past 12 years. The stone facing solid, the drainage swales on either side clear, the dam's crown wide enough to drive a truck across, and inspectable on foot in 10 minutes. Caleb stood on the dam's crown and looked downstream. From this elevation, the full eastern boundary was visible. The drainage corridor running south from the dam's base, the creek channel at its center, the cleared and graded area the HOA had converted into a park visible as a green rectangle against the darker texture of the surrounding timber. The parking lot was visible from here too, the asphalt catching the February light at the right angle, his park benches, his gravel path, his trailhead sign. In his drainage corridor, 3 acres downslope from a dam holding 4 acres of cold water behind 180 feet of compacted earth. He looked at the 2 36-inch slide gates on the dam's eastern face, cast iron, the same hardware his grandfather had specified in 1952, maintained and functioning, set to their standard winter partial open position. Both gates open approximately 40%, enough to pass the creek's winter base flow downstream while keeping the pond at its managed winter level. In summer, the gates came down further, reducing the release to maintain the pond through the dry months. In a wet spring, he opened them wider, managing the pond level against the incoming volume. He had been managing those gates since his father's hands were no longer able to turn the wheel cranks. 30 years of seasonal adjustment, spring and fall, the specific knowledge of how much water was behind the dam, and how much was moving through it. He looked at the benches. He pulled out his phone and called Sylvia Crane. Sylvia had been his family's property attorney since 2009. She had handled the estate when his father died, had negotiated the timber easement renewal in 2014, and had reviewed the survey when a neighboring landowner had disputed the northern boundary in 2019. She knew the Drummond property the way property attorneys come to know the land of long-term clients, not just from documents, but from the history behind them. She answered on the third ring. "Caleb, you're back." "I'm standing on the dam," he said, looking at a park. A pause. "Burl's been calling me too," she said. "Tell me what you're seeing." He described it. The parking lot, the graded field, the benches, the trail, the sign, the relocated fence enclosing 3 acres of his land inside the HOA's eastern edge, the trail map with 2 creek crossings, footbridges the HOA had apparently installed in Drum Creek without his knowledge or authorization. "The trail crosses my creek twice," he said. "They put structures in my creek." "How long has the park been operational?" Burl's first text was October. "Based on what I'm looking at, the paving and construction finished in November or December. 3 residents are on the trail right now." "Caleb, don't approach the residents. Don't engage anyone on the property today." "I know," he said. "I called you first." "Good. I'm going to need a boundary surveyor out there by the end of the week. Don't touch anything, don't move anything, and take photographs of everything before you go inside. I want documented evidence of the park as it currently stands before anything changes." "Burl has photographs," Caleb said. "He's been documenting since October." Another pause. Longer. "How many photographs?" "I don't know yet. I just got home." "Call him tonight," Sylvia said. "I need to know what he has before I file anything." Caleb looked down at the park one more time. The woman with the stroller had reached the far end of the gravel path and was turning back toward the parking lot. The 2 men in athletic wear were deeper in the timber, their voices inaudible from the dam. "Sylvia, do you know what this is? The park is directly below the dam." "I understand the geography." "The inundation zone. If this dam releases—" "I know what an inundation zone is," Sylvia said quietly. "And I know what the NC Dam Safety Program is going to say when I tell them someone built a public park in one without a permit." A beat. "Make your calls. Come to my office Thursday morning." Caleb put the phone in his pocket. He stood on the dam for a few more minutes. The pond behind him, cold and still in the February air. The park below him, 3 acres of someone else's vision, built on his family's land without a conversation, without a survey, without a permit, without a single phone call to the man whose grandfather had built the dam upstream in 1952. He looked at the gates, the wheel cranks his grandfather had installed, the slide gates set to their standard winter position, releasing a managed trickle of Drum Creek into the corridor below. He did not reach for the cranks. He had not decided yet whether he would need to. The Drummond property had a specific character that took time to understand if you hadn't grown up with it. It was not scenic in the way the Smokies were scenic. It lacked the dramatic elevation change and the postcard views that drew the tourist economy to the region. It was working land, timber, creek, field, managed with the continuity of a family that had understood from the beginning that the land's value was in its stewardship over time, rather than its conversion to any single use. Calvin Drummond had bought the 340 acres in 1946 for $8,200. He had spent the next 40 years cutting timber on a sustainable rotation, running cattle on the upper fields, and maintaining the creek corridor as the natural drainage system it was, not developing it, not clearing it, not improving it into something it wasn't. Caleb's father had done the same, and Caleb, after the estate settled and the land became his to steward, had continued the pattern. Timber inventory, creek management, the seasonal gate adjustments on the dam, the fence line walks Burl now made in his place. 16 months away, the longest he had been off the property since he inherited it. He had left a functioning brush line on the eastern boundary, the natural edge of mixed hardwood regeneration that marked the transition between his managed timber stand and the residential development. He had returned to find a parking lot, a park, and a sign telling residents which trails were designated. The eastern drainage corridor, the Drum Creek floodplain, was not incidental land. It was the functional heart of the property's hydrology. The creek gathered the upland runoff, the dam impounded it, the spillway managed its release, and the downstream corridor carried it south. The corridor was not beautiful in a landscaped sense. It was brushy and irregular and seasonally wet and difficult to walk through without getting your boots muddy. It was exactly what a creek floodplain is supposed to be. The HOA had graded it flat, seeded it with turf grass, and put benches in it. Caleb drove back down to the farmhouse, called Burl, and asked how many photographs he had. Burl said he'd need to count, but it was over 200. "Bring them Thursday," Caleb said. "All of them." Warren Gill had picked up on the second ring because he was a man who picked up. 20 years in residential development had wired him for responsiveness. The deal that goes sideways because you didn't answer. The contractor who makes the wrong decision because you weren't reachable. He kept his phone on his person and answered it. He had been expecting this call since December, when the park had been completed, and the question of the adjacent landowner's awareness had surfaced briefly in a conversation with Douglas Fitch, his attorney, before being deferred to the new year. The new year had arrived. So had Caleb Drummond. Caleb identified himself, described his property, and described what he was looking at from the dam. Warren's response was the response he had prepared. The eastern strip had been unmaintained and functionally abandoned for the entire 20-year existence of Ridgeline Estates. The HOA had improved it in good faith as a community amenity, investing in a project that added genuine recreational value to the development. North Carolina's adverse possession statutes recognize the principle that productive community use of land could, over time, establish rights. Warren did not claim the 10 years had run, but the principle was relevant to how a court might view the equities. Caleb let him reach the end of it. "Mr. Gill, yes. You built a park in a creek floodplain. My creek, my floodplain." A pause. "My dam is upstream right now, holding back 4 acres of water above your park benches." The line was quiet. "I'd strongly suggest you call your attorney before your residents come back tomorrow morning." He ended the call. He stood on the dam with the phone in his hand and looked at the corridor below. The bench visible from this angle, the parking lot, the path entering the timber. The gates were in front of him, the wheel cranks cold in the February air. He did not reach for them. He put his phone in his jacket pocket and walked back down through his timber toward the farmhouse. Some things didn't need to be rushed. David Ensley had surveyed the Drummond property twice before, the 1989 timber easement and the 2011 tax appeal boundary work. He knew the eastern line the way a surveyor knows a line he has run before, from the monuments, from the deed calls, from the reference points that don't change between visits. He arrived Thursday afternoon with his crew. They worked through Friday. Caleb walked the boundary with him Friday morning, while the crew set pins. David moved methodically, planting his rod at the northeast corner monument, reading his instrument, moving south along the recorded bearing. He talked as he worked. "Your deed calls this boundary at a consistent bearing from the northeast pin to the southeast pin, 2,200 feet. Same call since 1946. The monuments are where they've always been." "Where's the HOA fence now?" Caleb asked. David pointed west. "About there, 80 feet inside your line. And everything between the fence and where we're standing is yours, has always been yours. The fence was moved during the construction. Whether it was a contractor error or a deliberate decision, I can't say. The recorded boundary hasn't moved." The sealed plat was complete by Friday evening and filed with the Haywood County Recorder Saturday morning. The plat note was unambiguous. All constructed improvements identified herein as park infrastructure, including the paved parking area, graded field, walking path, trail system, footbridges, and all associated structures, are located entirely on the Drummond parcel, as described in Deed Book 847, page 312, Haywood County Register of Deeds. No portion of the identified improvements falls on the adjacent Ridgeline Estates parcel. Every square foot, every bench, every orange blaze on every tree, every footbridge post driven into Caleb's Creek, all of it on Drummond land. Sylvia had been looking at the FEMA flood maps since Tuesday. Her first call after the plat was filed went to Janet Wilcox, the Haywood County Floodplain Administrator, a position Janet had held for 11 years. long enough to know every regulated creek corridor in the county without pulling up a map. Janet, construction activity on the Drum Creek Corridor, eastern Haywood County. I have a sealed plat filed this morning, confirming the work is on private land. The corridor is Zone AE on the current FIRM. The Drummond property, Janet said. I got a complaint letter in October, sent an inquiry to the HOA. They said it was their common area. It isn't. The plat confirms the boundary. The park infrastructure, parking lot, graded field, trail system, sits entirely within Zone AE. A pause. No floodplain development permit was ever submitted for that corridor. One permit on record, a grading permit pulled by the contractor listing the owner as the HOA, with no disclosure of the floodplain location. I need to do a site inspection. Wednesday works. I'll have the gate open. The county notification went out by letter that afternoon, with the survey plat and a FEMA map overlay showing the park footprint sitting inside the Zone AE boundary. Zone AE is the 100-year regulatory floodplain, the designation that triggers mandatory county floodplain development permits before any grading, filling, or construction. The HOA had graded 3 acres, paved a 24-space parking lot, and installed 2 creek structures without a permit application, without an engineer's impact analysis, and without a no-rise certification. The Army Corps notification went out the same day. Section 404 of the Clean Water Act governs fill placement in jurisdictional wetlands and waterways. The National Wetlands Inventory mapping showed 2 wetland patches within the park footprint. The parking lot's gravel base and asphalt, fill material, placed in jurisdictional wetlands without a 404 permit, was a federal violation independent of the county issue and independent of the ownership dispute. The footbridge footings in the creek channel were a separate 404 question. 3 regulatory agencies were now in the picture before Sylvia filed a single page in civil court. The dam classification issue was the one that had kept her desk lamp on until 10 o'clock on Wednesday night. The Drummond Dam, NC Dam Safety Program Registry Number NC2847, registered 1986, owner Caleb Ray Drummond, carried a low-hazard classification. The classification narrative in the registry described the downstream inundation zone as undeveloped woodland and agricultural land, no structures, no occupancy. That description had been written during Caleb's last inspection in 2021. The HOA had changed it in November. The NC Dam Safety Program's hazard classification system is built on consequence, not probability. A low-hazard dam fails into empty land. Economic loss, no lives at risk. A significant hazard dam fails into land with periodic human occupancy, potential loss of life. The regulatory burden scales accordingly. Significant hazard requires licensed engineer inspections on a defined schedule, updated inundation mapping, and a formal emergency action plan, identifying downstream populations and evacuation protocols. A public park with a 24-space parking lot, 2 benches, and a 1.2-mile trail system used by 180 households represented exactly the kind of occupancy change that moved a dam from one classification column to the other. Sylvia called Marcus Webb in Asheville on Thursday morning. Marcus had worked with the NC Dam Safety Program on Haywood County projects for 15 years, someone who understood both the engineering and the regulatory language. The downstream inundation zone of a registered low-hazard dam, she said. Public park, regular community use, installed without the dam owner's knowledge. Does that trigger reclassification? Significant hazard, yes. Possibly high hazard depending on how many people use the trail and how far the inundation mapping extends. What's the dam? 1952, earthen dam, 180 feet, 14 feet at crest. Inspection, inundation mapping, emergency action plan. $85,000 to $140,000, depending on what the inspection finds. Could go higher if there's structural remediation. That falls on the dam owner. The dam owner is the regulated party. The classification requirement attaches to the registration. The dam owner had nothing to do with the park. The park was built by the adjacent HOA on the dam owner's land without consent. A longer pause. Then you have a clean causation argument. The HOA created the occupancy that triggered the reclassification. The costs flow directly from their construction. Marcus submitted the formal classification argument to the NC Dam Safety Program the same week Sylvia filed with the county and the Corps. 3 regulatory tracks, all opened within 5 days, each one independent, each one running on its own timeline, regardless of what the civil case did. Douglas Fitch called Friday at 4:47 p.m. The timing told Sylvia what she needed to know. A week spent trying to find ground to stand on, arriving at Friday without finding it. He led with adverse possession, open, notorious, continuous use of the Eastern Strip, community investment, the equitable weight court sometimes gave to significant improvements in trespass remedy cases. Douglas, 14 months is 11% of the 10-year statutory period for adverse possession in North Carolina. Your client doesn't have a claim. He has a construction timeline that my client's caretaker documented in 214 photographs. He moved to good faith improvement of apparently abandoned land. The county GIS shows the parcel owner as Caleb Drummond. It has shown that since 1946, a 5-minute search before the first survey stake was driven would have identified the ownership. Your client chose not to do that search. On the floodplain, impervious surface in a FEMA Zone AE floodplain, structures in a regulated waterway, no county permit, no Section 404 authorization. Those violations exist whether the land belongs to my client or yours. The Army Corps doesn't adjust its enforcement calendar for civil settlement negotiations. On the dam, the reclassification argument is before the NC Dam Safety Program. If it's confirmed, and Marcus Webb believes it will be, my client is looking at $85,000 to $140,000 in compliance costs for a dam he has maintained properly for 30 years. Costs he is facing because your client built a public gathering space in a dam's inundation zone without asking anyone. Douglas, we'd like to explore a resolution. 10 days, Sylvia said. A written remediation proposal. What your client will do about the trespass, the floodplain violations, and the dam reclassification costs. Specific timelines, specific funding commitments. If I don't have that document in 10 days, I file. She put the phone down and noted the deadline on her calendar. The 10 days passed. Douglas Fitch did not send a proposal. Sylvia opened a new document and started drafting the complaint. Burl Hensley was not a man who used more words than the situation required. He was 67, drove a 2009 Ford Ranger with 187,000 miles on it, and had been looking after the Drummond property since Caleb's father died in 2013. 11 years of gate checks, fence line walks, and the quiet vigilance of someone who understood that 340 acres of unoccupied rural land stays unoccupied only as long as somebody is paying attention. When the contractor's flatbed appeared on the access road in September with a Caterpillar D6 dozer and a set of survey stakes, Burl drove his Ranger to the boundary line and watched from the gravel shoulder. The crew waved at him. Burl did not wave back. He took out his phone. Caleb had upgraded it the year before specifically because the camera was better, and photographed the dozer, the survey stakes, the contractor's truck, and the crew. He checked the time, 8:14 a.m. He drove home and started a notebook. Over the 14 months that followed, Burl documented every stage of the construction in the same methodical way he documented everything, dated, time-stamped, described in the notebook alongside the photograph number. The boundary fence removal, the dozer grading, the parking area basework and asphalt pour, the footbridge installations at the 2 creek crossings, the bench delivery. He photographed the delivery truck, the packing labels, the installation crew, the trailhead sign going up, the trail blazing. He walked the tree line and photographed each orange blaze mark on each of Caleb's trees, noting the GPS coordinates in the notebook alongside the photograph. In October, 1 month in, he had taken his complaint letter to the Haywood County Planning Office in person and waited for a receipt. The county had sent an inquiry to the HOA. The HOA's attorney had responded that the construction was on HOA common area land. The county closed the file without requesting a survey. Construction continued. Burl kept photographing. When Sylvia spread the 214 prints across her conference table, organized by month, she called Caleb that evening. Your caretaker built your case for you. Burl builds everything carefully, Caleb said. It's why I hired him. The subpoena for the HOA's internal records went out the week after Sylvia filed her county and Corps notifications. 2 boxes arrived. 4 years of board meeting minutes, financial records, contractor correspondence, and all communications related to the Eastern Boundary Project. Sylvia read through them over 2 days. She called Caleb when she finished. Warren presented the park to the board at the June meeting, she said. He called it the Eastern Green Space Initiative, described the Eastern Strip as the development's natural amenity buffer, underutilized, ready for improvement. He had a contractor's rendering and a $187,000 budget. He called my land the development's amenity buffer. He had been calling it that institutionally since before he was president. The Eastern Strip had been characterized that way in the HOA's informal understanding since the development opened. Adjacent rural land that looked like a buffer, so it got treated like one. Nobody verified whether it was actually theirs. 2 board members had asked the question Warren should have answered before he brought the project to a vote. Helen Pratt, a retired schoolteacher from Maggie Valley, 2 years on the board, had raised it first. Her words, recorded in the June minutes, "Before we approve any expenditure on the Eastern Strip, I want to see a survey confirming that land is ours. We should not be spending $187,000 on property we haven't verified we own." Donald Sue, a structural engineer, had seconded it directly. A boundary survey costs $3,000. Let's spend the $3,000 before we spend the $187,000. Warren's response. He had asked the HOA's landscape contractor to walk the boundary. The contractor had confirmed the Eastern Strip was within the development's natural zone. Warren was satisfied. His landscape contractor mowed grass. He was not a licensed surveyor. He could not legally establish a property boundary, and his walk of the line was not a legal instrument of any kind. Warren had substituted a landscaper's informal opinion for a $3,000 professional survey, and used it as due diligence for an $187,000 capital project on land he had not verified he owned. The vote? 5-2. Helen Pratt and Donald Sue in the minority. 3 board members deferring to Warren's 20 years of residential development experience. The contractor was engaged the following month. The document that moved the case from negligence to willfulness was not in the board's records. Sylvia had noticed a reference to outside counsel in the contractor correspondence. A brief mention in an August email chain between Warren and the project manager that referenced a boundary opinion they were waiting on. She subpoenaed the HOA attorney's separate file. Philip Castor was a Waynesville real estate attorney. Warren had retained him in August, 3 months before the park was completed, for what the retainer letter described as a boundary confirmation matter on the eastern development edge. Philip's response letter was dated August 19th. 4 paragraphs. The first confirmed he had reviewed the county deed and tax records for the eastern boundary parcels. The second identified the owner of record, Caleb Drummond, deed book reference, tax parcel number, current address on file with the county. The third paragraph was the one Sylvia marked with a red tab and read to Caleb over the phone. "I want to be direct with you, Warren. The county tax records and deed show this parcel in the name of an individual owner, not the HOA. Before the association proceeds further with any construction on this strip, you should obtain a licensed boundary survey to confirm the property line, and, if the survey confirms the parcel belongs to the adjacent landowner, cease construction immediately and consult with your attorney about your exposure." The fourth paragraph offered Philip's fee for further work if Warren wanted to proceed with a formal survey and title review. Warren had not responded to Philip Castor's letter. He had not obtained the survey. He had not ceased construction. He had not told his board that his own outside counsel had identified a different name on the county deed records. The park was completed in November, 11 weeks after Philip Castor had put Warren on written notice that the land might not belong to the HOA. Philip Castor's letter became Exhibit F in Sylvia's filing. It answered, in Warren's own attorney's handwriting, every question about what Warren knew and when he knew it. Douglas Fitch's adverse possession letter arrived 2 weeks after the remediation proposal deadline had passed without a response. 4 pages. The HOA had been in open, continuous, and notorious use of the Eastern Strip since September of the prior year. The community had invested $187,000 in good faith improvements. The court, Douglas argued, should weigh those equities when fashioning a remedy. Specifically, should consider awarding Caleb damages rather than ordering the park removed. Sylvia called Caleb after reading it. He's not arguing they've perfected the claim, she said. He's arguing 14 months of use and $187,000 of investment should influence what the remedy looks like. He wants the court to let the park stay and write you a check instead of ordering demolition. How close is 14 months to the statutory period? North Carolina requires 10 years of continuous hostile use. 14 months is less than 15% of that. He has no colorable adverse possession argument. This letter is a damages argument dressed in adverse possession language. Caleb was quiet for a moment. Sylvia, the park is in the inundation zone. I know. If the dam safety reclassification goes through, if Marcus's argument holds, there are 180 Ridgeline Estates families whose HOA president built a public gathering space in the flood corridor below a functioning earthen dam without telling them. He paused. The remedy isn't a check. A check doesn't move the benches out of the flood path. I know that, Sylvia said, and the court is going to know it too once Marcus's classification argument is part of the record. A judge fashioning a remedy in a trespass case doesn't order preservation of an unpermitted structure in a FEMA floodplain below a dam that's being reviewed for hazard reclassification because of that structure. File Monday, Caleb said. Monday, Sylvia confirmed. She added the filing deadline to her calendar, closed the Douglas Fitch letter, and pulled up the blank complaint template. 14 months, 214 photographs, one letter from Warren's own attorney warning him to stop. He had not stopped. Now the filing would. The NC Dam Safety Program's letter arrived on a Tuesday, 3 weeks after Marcus Webb had submitted the classification argument. Sylvia had expected 4 to 6 weeks. 3 weeks told her the agency had reviewed the argument and found it uncomplicated. The kind of response time that happens when the facts are straightforward enough that no one needs to deliberate long. The letter was addressed to Caleb Drummond as the registered dam owner. Its finding was direct. The construction of a public access recreational facility with regular human occupancy in the Drummond Dam's downstream inundation zone constituted a material change in the impoundment's hazard potential. The program was initiating a formal reclassification review from low hazard to significant hazard, effective immediately. During the review period, Caleb was required to commission a full dam safety inspection by a licensed professional engineer, submit updated inundation mapping, and prepare an emergency action plan. If significant hazard was confirmed, structural remediation assessment would follow. Estimated compliance cost, $85,000 to $140,000. Cause of the reclassification trigger, the downstream occupancy change created by the HOA's park construction. Caleb read it at the kitchen table in the farmhouse his grandfather had built and called Sylvia. It went through. I saw it. I'm filing the emergency motion this afternoon. I want the court to assign the compliance costs to the HOA and require them to fund the inspection while the civil case runs. Judge Thomas Whitfield reviewed the motion on an expedited basis. 4 days after Sylvia filed, his temporary order came down. The Ridgeline Estates HOA was required to deposit $90,000 into a court-managed escrow account to fund the dam safety inspection and preliminary compliance work pending the full hearing. The HOA's board convened an emergency session the evening the order was served. Helen Pratt, who had voted no on the park project and had been keeping her own parallel record of board proceedings since Philip Castor's letter surfaced in Sylvia's subpoena, described it afterward as the meeting where Warren Gill finally ran out of the confidence that had carried him through the previous 14 months. Sylvia filed the full Superior Court action on a Thursday. 3 simultaneous tracks, structured to create pressure on every front at once, and to make clear that no single settlement negotiation could resolve the full picture. In Superior Court, trespass by permanent improvement, dam reclassification damages, unjust enrichment, and the punitive count built on Philip Castor's August letter, the civil action that Warren and Douglas Fitch would have to negotiate. With the Army Corps of Engineers Wilmington District, the formal Section 404 violation complaint. Unauthorized fill in a jurisdictional wetland. The parking lot base, the gravel path substrate, the footbridge footings in the creek. The Corps enforcement process was federal and independent. It ran on its own timeline. It answered to its own standards, and it could not be resolved by a private settlement agreement between Caleb and the HOA. Whatever the civil case produced, The HOA was going to have to satisfy the Army Corps separately with the NC Floodplain Mapping Program, a technical notification that the parking lot's impervious surface had altered the hydraulic characteristics of the Drum Creek corridor in ways that affected the floodplain calculations for downstream properties. A secondary issue, a third agency, another thread that Douglas Fitch would need to track. Douglas called the day after the filings. "How many agencies are you running simultaneously?" he asked. "As many as the facts support," Sylvia said. "Your client built in a FEMA floodplain, in a dam inundation zone, in a jurisdictional wetland, on someone else's land. The agencies aren't a strategy, they're the consequence of what your client actually did." What Warren Gill had not researched before breaking ground in the Drum Creek corridor was the specific legal character of Caleb's relationship with the water. North Carolina follows the riparian rights doctrine. A landowner whose property borders a watercourse holds the right to the natural flow of that water through their land, subject to reasonable use by other riparian owners downstream. The Drummond family had held senior riparian rights on Drum Creek since Calvin Drummond purchased the land in 1946. The dam was the physical expression of those rights, a structure built to impound the creek for beneficial agricultural use, managed through the spillway gates to regulate downstream flow. The two 36-inch slide gates on the dam's eastern face were the mechanism. Under normal seasonal operation, the setting Caleb had maintained for 30 years, both gates held at approximately 40% open, releasing a managed base flow into the drainage corridor, enough to keep the creek running, enough to maintain the pond at its managed level. The gates could be opened wider, fully open, both gates simultaneously. The Drummond Pond could release its full impounded volume downstream in a controlled, high-flow event. Not a dam failure. The dam would remain intact, a managed release within Caleb's riparian rights that would bring the drainage corridor up to its natural bank-full capacity. The corridor that currently contained a parking lot, 2 benches, and a gravel walking path. Sylvia had confirmed with the NC Division of Water Resources that a managed release within the bounds of Caleb's senior riparian rights and the dam safety regulations was lawful. She had noted that confirmation in her file without mentioning it to Douglas Fitch. Caleb had not changed the gate settings. He had thought about it. He had stood at the spillway on 3 separate mornings in the weeks after the filings, looking at the gates and looking at the park below, running the arithmetic of what a full release would do to the parking lot asphalt and the bench legs and the gravel path substrate. He had left the gates where they were. The paperwork was moving. He didn't need the water. Not yet. Warren came on a Saturday morning, 3 weeks after the filings. He parked in the HOA's park, in the parking lot on Caleb's land, as he apparently still thought of it, and walked to the relocated boundary fence. He stood at the wire and called across the graded field toward the timber stand. Caleb was on the upper plateau checking the spillway, the way he did most mornings. He saw Warren at the fence from the dam crown and walked down through the timber. They stood on opposite sides of the wire. Warren on the graded park side, in the inundation zone, the benches visible behind him. Caleb on the natural land side, the pond and the dam visible above him through the tree canopy. Warren opened with the community framing, 180 families, a good faith investment, a resolution that acknowledged the neighborhood's interests without requiring the courts to run the full course. Caleb listened to it completely. "Mr. Gill, do you know what a dam inundation zone is?" Warren shifted his footing slightly. "I understand there are regulatory concerns about the proximity. It is the area that receives the water when a dam releases flow." Caleb looked up at the plateau. The pond was visible at the dam's crest, flat and cold in the morning light. "Your parking lot is in my inundation zone. Your benches are in my inundation zone. Every foot of that trail from the trailhead to the upper crossing is in my inundation zone." A pause. "I manage those gates. My father managed them before me. 30 years. Warren looked at the dam, at the plateau, at the water visible above the dam's crest. The silence that followed was the silence of a man who had spent 14 months treating a creek corridor as a landscaping opportunity, and was, for the first time, considering it as a hydraulic system with an operator. "Have your attorney call Sylvia," Caleb said, "by Wednesday, with a real proposal, not the adverse possession letter, not the community investment argument, a remediation proposal. What comes out, what gets restored, what gets paid, and when." Warren said nothing. Wednesday, Caleb repeated. He turned and walked back up through the timber toward the plateau. He did not look back at the gates when he reached the dam crown, though he was aware of them the way you are aware of any tool you have decided not to use yet. Warren Gill stood at the fence for a long time after Caleb disappeared into the tree line. He was looking at the pond above the park. He called Douglas Fitch from the parking lot before he drove home. Douglas called Sylvia that afternoon. "Warren wants to schedule a principals meeting," he said. "Wednesday," Sylvia said. "I'll send the conference details." She put the phone down and made a note in the file. "Gates still at standard setting. Caleb has not adjusted." She underlined it. It was the kind of detail that shaped a negotiation, the thing the other side knew you could do and were choosing, for now, not to. The principals meeting on Wednesday lasted 3 hours. Douglas Fitch came with a yellow legal pad and a position that had not materially advanced from his adverse possession letter. Warren sat beside him with the expression of a man who had spent the weekend looking at a dam and had arrived at the meeting understanding, for the first time, the full weight of what he had built and where he had built it. Sylvia presented the civil filing structure, 5 counts, the financial demand, the 3 regulatory tracks running in parallel. She set the Army Corps notification on the table, alongside the Dam Safety Program's reclassification letter and the survey plat. She did not editorialize. She let the documents describe the situation. Douglas asked for 60 days to prepare a response. Sylvia said she would file in 10. She filed in 9. The Superior Court complaint was 44 pages. The exhibits ran another 80. The sealed survey plat, Burrell's 214 photographs, organized chronologically, Philip Castor's August letter, the NC Dam Safety Program's reclassification notice, the Army Corps notification, the FEMA Zone AE mapping overlay, the HOA's board minutes from the June meeting with Helen Pratt, and Donald Sue's recorded survey objections, Warren's overruling response, and the contractor's grading permit listing the property owner as Ridgeline Estates HOA on land titled to Caleb Drummond. The complaint told the story in the sequence the evidence demanded. From the first survey stake in September to the dam safety compliance invoice Caleb was now facing because a retired developer had decided a creek corridor looked like a park. 5 counts. Count 1 was trespass by permanent improvement, the foundational claim. Every structure the HOA had constructed occupied Caleb's titled land without his knowledge or authorization. The survey was unambiguous. There was no boundary ambiguity to argue, no good faith reliance on a competing survey, no competing chain of title. The boundary had been in the same recorded position since 1946. The HOA's contractor had relocated the fence 80 feet inside that line and built a park in the space they had created. Philip Castor's August letter eliminated any argument that Warren had been unaware of the ownership question. He had been told directly, in writing, by his own retained attorney, that the county deed showed a different owner, and he had proceeded anyway. The trespass count included both the pre-notice construction, which was negligent, and the 11 weeks of post-notice construction that completed the project after Philip's warning, which was something else. Count 2 was unauthorized floodplain development. The HOA had graded 3 acres of FEMA Zone AE regulatory floodplain, installed 24-space asphalt parking in the drainage corridor, and placed footbridge structures in the creek channel, all without a county floodplain development permit, all without an engineer's no-rise certification, all without a Section 404 authorization from the Army Corps. The floodplain violation was not a subset of the trespass claim. It was an independent wrong that had altered the hydraulic function of the Drum Creek drainage corridor, increasing flood risk to properties downstream of Caleb's boundary. The county permit requirement existed specifically to prevent this kind of unreviewed modification to a regulated drainage system. Count 3 was dam hazard reclassification damages. This was the count Sylvia had drafted most carefully because it required establishing a causal chain that the HOA would attempt to interrupt. The argument that Warren's park construction had caused a regulatory classification change that had in turn imposed compliance costs on a third party who had done nothing wrong. The causal chain was direct, and each link was documented. The park placed human occupancy in the inundation zone. The NC Dam Safety Program's classification criteria required reclassification when human occupancy entered a previously undeveloped inundation zone. The reclassification imposed inspection, mapping, and emergency action plan requirements on Caleb as the registered dam owner. The compliance costs were a foreseeable consequence of building a public park below a registered dam, foreseeable to anyone who had read the Dam Safety Program's classification criteria, which Warren had not done before he broke ground. Count 4 was unjust enrichment. The $187,000 the HOA had spent on the park had been drawn from homeowner assessment funds under the board's representation that it was improving HOA common area land. The land was not HOA common area. It belonged to Caleb. The $187,000 had purchased improvements that were now permanently attached to his property. The parking lot base, the graded field, the bench pads, the footbridge footings, generating a benefit that resided in his land without his consent and without compensation. The unjust enrichment doctrine required that a party who confers a benefit on another's property at their own expense, without authorization, must be made whole. Count 5 was punitive damages. The predicate was Philip Castor's letter, 4 paragraphs dated August 19th, delivered to Warren's personal email, identifying the owner of record as Caleb Drummond, and specifically directing Warren to stop construction pending a survey. Warren had not stopped. He had not obtained the survey. He had not disclosed the ownership flag to his board. He had completed the project. Under North Carolina's punitive damages standard, willful or wanton conduct, defined as action taken with conscious disregard for the rights of others. Proceeding with a capital construction project on land your own retained attorney had identified as belonging to someone else was willful conduct without ambiguity. The financial demand was built from 5 independently documented figures, each supported by a licensed professional's assessment. Park removal and full land restoration, $94,000. A licensed contractor's estimate for demolishing the parking lot, milling the asphalt, excavating the gravel base, hauling the debris, removing the benches, extracting the 2 footbridge structures from the creek, including their driven footings, restoring the boundary fence to its recorded position with new posts and wire, and regrading the disturbed area to its pre-construction drainage contour. This figure assumed cooperation with the Army Corps remediation order, and was calibrated to satisfy both the civil and federal compliance requirements with a single mobilization. Floodplain remediation, $138,000. The restoration of the drainage corridor's natural grade, the removal of all impervious surface from the Zone AE area, revegetation of the disturbed ground with the native species mix the Army Corps had specified in its pre-enforcement consultation, and coordination with Janet Wilcox's office to confirm restored floodplain compliance. This figure was consistent with the Army Corps' own remediation cost estimate and would satisfy the Section 404 enforcement order. Dam safety compliance costs, $115,000. The midpoint of Marcus Webb's $85,000 to $140,000 range, covering the licensed engineer inspection, the updated inundation mapping, the emergency action plan preparation, and the preliminary structural assessment the significant hazard reclassification review required. If the inspection identified structural remediation needs, additional costs would be added to the demand. The $115,000 was the floor, not a ceiling. Unjust enrichment restitution, $187,000. The full amount drawn from HOA reserves for the park construction returned to those reserves, not to Caleb personally, but to the assessment fund from which 180 households had contributed it. The theory was that the homeowners who had funded the project deserved to have those funds restored to the common account, available for actual HOA common area improvements on land the HOA owned. Diminished property value, $210,000. A licensed Haywood County appraiser named Richard Oates had assessed the impact of 14 months of unauthorized occupation on the Drummond property's market value. His analysis identified 3 distinct impacts: the loss of the eastern boundary's timber management potential during the occupation period, as the graded corridor was no longer available for the selective harvest rotation Caleb managed; the reduction in the property's rural privacy character, a measurable component of its appraised value; and the carrying cost of the regulatory encumbrances, the Dam Safety Program review, the Army Corps notification, the county floodplain flag, that had attached to the property as a consequence of the unauthorized construction. Richard's total diminishment figure, $210,000. Punitive damages, $480,000, calibrated to the post-notice period, the 11 weeks between Philip Castor's August 19th letter and the park's November completion, and representing approximately 2.5 times the estimated cost of the construction, completed after Warren received written notice of the ownership question. The multiplier was consistent with North Carolina's punitive damages case law in property rights matters, where willfulness was established through documentary evidence rather than inference. Total demand, $1.224 million plus attorney fees. The Section 404 violation finding from the Army Corps arrived 6 weeks after Sylvia's notification filing. The Wilmington District's notice of violation was addressed jointly to the Ridgeline Estates HOA and to Piedmont Grading and Site Work, the contractor who had pulled the grading permit and executed the construction. The finding enumerated 3 specific violations: unauthorized fill placement in a jurisdictional wetland by the parking lot base installation, unauthorized fill in a FEMA Zone A, E, floodplain by the gravel path substrate, and unauthorized placement of structures in a regulated waterway by the 2 footbridge installations. The HOA had not applied for a Section 404 permit. No after-the-fact permit was available. The Corps did not issue retroactive authorization for unpermitted fill on land the applicant had no ownership interest in. The enforcement order was mandatory: full removal of all fill material from the jurisdictional area, restoration of original grade contours, and a wetland mitigation assessment to determine whether natural revegetation would be sufficient or whether active mitigation planting was required. Compliance deadline, 180 days from the notice date. Estimated remediation cost in the notice, $138,000. The Corps order was federal. It ran on the Corps' timeline, answered to the Corps' standards, and could not be negotiated away in a private civil settlement. Whatever Caleb and the HOA agreed to in Superior Court, the HOA was going to spend $138,000 satisfying the Army Corps separately. The civil settlement could determine who funded that work and under what terms, but it could not make the obligation disappear. Douglas Fitch called Sylvia the afternoon the Corps order arrived. "We need to move toward a consolidated resolution," he said. His tone had changed from the Wednesday meeting, less positional, more practical. The Corps order had converted a theoretical federal exposure into a documented compliance deadline. "My client's position has been consistent since the first phone call," Sylvia said. "The park comes out. The land is restored to its pre-construction condition. The damages are paid in full. The only thing that has changed is the documentation supporting that position has grown substantially." A pause. "Send me a serious opening proposal. I'll respond within 5 business days." Philip Castor had done everything right. He had been retained for a boundary confirmation matter. He had checked the county deed records and the tax parcel database, a straightforward title search that any competent real estate attorney would run as the first step of any boundary opinion. He had found the answer: Caleb Drummond, Deed Book 847, page 312, tax parcel number on file. He had written a clear letter communicating exactly what he had found and exactly what Warren needed to do about it. He had given Warren the path to resolution: get the survey, and if the survey confirms the other owner, stop. He had sent the letter. He had billed for his time. He had done his job. Warren had not responded to Philip Castor's letter. He had not retained him for the survey work the 4th paragraph offered. He had not mentioned the letter to his board. He had not called Douglas Fitch to discuss it. He had set it aside, in his email, in his mental accounting of the project's risks, and continued construction for 11 weeks until the park was complete. Helen Pratt's declaration, prepared at Sylvia's request and filed as a supporting exhibit to the punitive damages count, covered the board's vote record in precise detail: her no vote in June, Donald Sue's no vote, the specific language of their survey request: let's spend the $3,000 before we spend the $187,000, and Warren's overruling of that request with his landscape contractor's informal boundary walk as the substitute due diligence. Helen's declaration included one additional paragraph that Sylvia had not asked for, but that Helen had volunteered. Had Warren Gill presented the board with Philip Castor's August 19th letter, which I did not learn of until it was produced in Discovery, I would have moved to halt construction immediately and called for a membership vote on the project's continuation. I believe a majority of the board would have supported that motion. The park would not have been completed. $3,000 survey, requested in June, refused. Philip Castor's letter, delivered in August, ignored. $1.224 million in damages, filed in Superior Court. Warren Gill had been given 2 separate opportunities to stop before the consequences compounded to this scale. He had declined both of them. The arithmetic was, as Sylvia noted in her case summary memo, not subtle. The negotiation ran 8 weeks. Douglas Fitch's first proposal arrived 10 days after the Army Corps order, a structured offer that attempted to preserve the trail system through a negotiated easement while paying damages for the parking lot and graded field. The theory was that the trail, being a lighter footprint, might be separable from the heavier construction issues. Sylvia's response was 1 paragraph. The trail ran through the dam's inundation zone, crossed a regulated waterway twice with unpermitted structures, and existed on land the HOA did not own. An easement required the landowner's consent to grant. Caleb was not granting one. The trail came out with everything else. Warren's second proposal offered a license agreement, formal, recorded, annual fee, for the full park footprint. Sylvia returned it the same day. A license did not resolve the Army Corps enforcement order. A license did not reverse the dam hazard reclassification. A license did not address the punitive count built on Philip Castor's letter. There was no version of the park staying that closed all 3 regulatory tracks and satisfied the civil demands simultaneously. By week 5, Douglas accepted the removal as the non-negotiable baseline. The negotiation moved to money. The financial gap closed steadily across weeks 5 through 7. Restitution, remediation costs, and dam safety compliance were documented precisely enough that neither side had room to argue the figures. The last number to settle was the punitive component, and it was the last because it was the one tied directly to Warren's personal exposure. The HOA's directors and officers carrier had issued a reservation of rights letter 2 weeks into the negotiation, citing Philip Castor's August letter as the basis for an intentional act exclusion analysis. The carrier's position, a board president who received written notice from his own retained attorney, identifying a different owner on the county deed records, and who completed construction anyway without disclosing that notice to his board, had not made an errors and omissions mistake. He had made a decision. The intentional act exclusion applied to decisions. Warren settled the week his carrier confirmed the exclusion covered the full post-notice construction period. The final agreement was signed on a Thursday morning. Sylvia called Caleb from the parking lot of the Waynesville courthouse. "It's done," she said. "All of it?" "All of it. Removal starts when you want it to start." Caleb called Burl before he called anyone else. The contractor arrived the first Monday of November. Burl was at the eastern boundary at 7 a.m. with his thermos and his phone. The same boundary, the same position he had occupied on the September morning 14 months earlier, when the contractor's flatbed had come the other direction with a dozer on it. He did not wave at this crew either. The parking lot came up first. The milling machine moved across the asphalt in overlapping passes, cutting the surface into manageable sections that the loader scooped and dropped into dump trucks. The gravel base came out behind it, excavated, loaded, hauled. The subgrade was exposed by Wednesday afternoon, stripped back to raw earth, the drainage corridor's natural soil visible for the first time since the previous year's paving. The gravel path came next, the surface material raked and loaded, the substrate excavated, the footbridge structures at the 2 creek crossings unbolted and lifted by a small excavator working from the bank. The footbridge footings had been driven 18 inches into the creek bed. Getting them out required a hydraulic breaker and most of a day. Burl photographed all of it. The benches were loaded onto a flatbed Wednesday afternoon. 2 dark green park benches, still structurally sound, the paint barely weathered from one season of use. They went to the county equipment surplus lot. Burl noted their departure in his notebook with the same precision he had noted their arrival. The boundary fence was relocated Friday. The encroachment fence, set 80 feet inside the recorded line during the park construction, was pulled post by post, the wire rolled and stacked. New posts were driven on the recorded boundary, New wire strung the full 2,200 feet of the eastern edge. The fence that the 1946 deed had always described, back in the position it had occupied before someone decided a creek corridor was a landscaping opportunity. The trailhead sign came down last. The crew unscrewed it from the cedar post on Friday afternoon. One of the workers set it in the pickup bed face up. The routed letters, the forest green paint, Ridgeline Estates Nature Preserve. Maintained by the Ridgeline Estates HOA. Please stay on designated trails. It went to the surplus lot with the benches. The regrading ran through the following week. The drainage corridor recontoured to its natural profile. The disturbed ground seeded with the native species mix the Army Corps had specified. Temporary erosion control fabric pinned on the steeper sections to hold the seedbed while the vegetation established. The Army Corps' restoration ecologist made 2 site visits. Janet Wilcox came out on the final day and walked the corridor with the contractor's project manager, checking the floodplain remediation against the compliance checklist. The contractor demobilized on the last Friday of November. Burl walked the boundary alone after the crew left. The fence on the recorded line, the corridor open, the creek running clean through it, the raw earth where the parking lot had been already showing the first faint green of the seeded native mix catching in the November light. He took 4 photographs, noted the date and time, closed the notebook. The membership petition for Warren Gill's removal reached 142 signatures in 3 days. The vote was held at a December special meeting, 142 to 11, a margin that required no interpretation. Warren had spent 20 years in residential development, trusting his instincts over surveyors, over his own attorney's written warning, over 2 board members' specific request to spend $3,000, before spending $187,000. He had built a park in a regulated floodplain below a registered dam on a neighbor's land, and had cost 180 Ridgeline Estates households $1.124 million in a year of proceedings. He sat in the back row of the meeting room and received the count without response. He left without addressing the floor. Helen Pratt was elected by acclamation at the same meeting. Her first act as president, she retained David Ensley's firm, the same Canton surveyor Caleb had used, and commissioned a complete boundary survey of all Ridgeline Estates, HOA common area perimeters. The sealed plat was filed with the county recorder before Christmas. It established, in a recorded instrument, the precise boundaries of every parcel the HOA actually owned. Her second act, a letter of apology to Caleb Drummond. She wrote it herself, had every board member sign it, and delivered it to his door on a Tuesday afternoon in December. Caleb read it at the kitchen table, called Sylvia. Helen Pratt brought an apology letter. She told me she'd had the language drafted since August, Sylvia said, since the day she first read Philip Castor's letter in the Discovery production. She said she'd been waiting for the right moment to deliver it. Marcus Webb submitted the revised classification analysis to the NC Dam Safety Program in December. His argument was the mirror of the argument he had submitted in the spring. The downstream occupancy that had triggered the reclassification review no longer existed. The park infrastructure had been removed under Army Corps supervision. The inundation zone was restored to undeveloped land. The county floodplain administrator had issued a compliance confirmation. The original low-hazard classification basis, undeveloped woodland and agricultural land, no structures, no occupancy, was accurate again. The program reviewed Marcus's submission alongside the contractor's completion certificate, the Army Corps sign-off, and Janet Wilcox's compliance letter. The determination came back in January. The Drummond Dam's hazard classification was restored to low hazard. The Significant Hazard Compliance Program, the $85,000 to $140,000 inspection, mapping, emergency action plan, and potential structural remediation that had been hanging over Caleb since the spring, was no longer required. The court-ordered escrow was dispersed. The portion spent on the dam safety inspection and the preliminary inundation mapping work during the reclassification review period was released to Caleb, consistent with the settlement's dam safety reimbursement provision. The remainder went back to the HOA. On a January morning, Caleb walked up to the plateau and adjusted the spillway gates. Both gates back to their standard winter setting, approximately 40% open, the same position they had been in when he left for Oregon 16 months earlier. The pond behind him at its managed winter level, the creek below resuming its standard base flow into the drainage corridor. the corridor that was, once again, empty land. February came cold and clear to the Haywood County foothills. Caleb was at the spillway on a Tuesday morning, the water level marker reading exactly where February should read after a wet January, the dam performing exactly as a properly maintained 1952 earthen dam performs when no one has built a park in its inundation zone. He heard Burl coming up the path from the lower field before he saw him, the specific cadence of Burl's boots on the frozen ground, unhurried, the thermos visible in his left hand. Burl came to stand beside him at the spillway deck. They looked south together, the pond still behind them, the drainage corridor below, the eastern boundary fence on the recorded line, the brush coming back along the creek edge where the graded park field had been. Raw in places, the new native seeding not yet dense enough to fully cover the disturbed ground, but coming. The way disturbed ground comes back when you give it the right seed and leave it alone. Empty, clean, his. Burl looked at the gates, at the pond, at the corridor below. 214 photographs, he said. Every one of them worth it, Caleb said. A pause. Burl drank his coffee. His breath showed in the cold air. You ever actually going to open them all the way? Caleb looked down the corridor, the creek channel catching the February light, the water moving the way it had moved through that drainage since before the dam existed, since before the property had a deed or a name or a family attached to it. Didn't need to, he said. The paperwork did it. Burl nodded once, looked at the view, the corridor, the fence line, the ridgeline estate's roof lines visible through the tree canopy on the far side of the boundary. Still, he said, would have been something to see. Caleb looked at the gates. The wheel cranks cold in the February air. The same cast iron his grandfather had specified in 1952, maintained and functional, and set exactly where they needed to be. Yeah, he said, it would have.